let's start with Shankster and Carpenter versus Johnson. Okay, that's number 25-187. All right, this is Carpenter and Shankster's petition for anti-harassment order against Johnson. All right, so I'm going to tell you a little bit about how this is going to go, and this will apply to every case where we have a hearing this morning, so this applies to everybody. In these cases, I'm going to call the case, I'm going to swear the parties in, and then the petitioner will present their case first. The petitioner is the person who initiated the case by filing it in court. I'll listen to what the petitioner has to say. Then after that, I'll listen to what the respondent has to say and make a decision as to whether to issue an anti-harassment order. It's the petitioner's burden to prove by a preponderance of the evidence that they're entitled to an anti-harassment order or a protection order. During the time that the other party is telling me their side of the case, I'm going to ask that if you hear that other party say things that you don't agree with, that you don't believe are true, to not interrupt them, to just let them tell me their side of the case, because I'm going to give you the same opportunity as well. So when you tell me your side, that other party won't interrupt you either. I may need to ask you questions once in a while just to make sure that I understand what you're claiming or what your defense is, or if I need clarification. And then I'll tell you what my decision is, and I'll explain to you why I made the decision that I did. So the other thing I'm going to ask you to keep in mind is that mostly I'm going to decide these cases based on information that you filed in writing, if you filed in writing. And then the testimony or the statements that you give me here today orally, you don't need to repeat the things that you've already said in writing. If you've made a statement in writing, if you filed that with your case or in response, then it's already part of the record and you don't have to say it again in order to kind of make it real. So keep in mind, I've already got those and I've read them. So, all right, we're going to get started with Carpenter versus Johnson. Carpenter and Shankster versus Johnson. Can I have the parties raise your right hands, please? All right, and do each of you swear the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
I do.
So, Carpenter, Shankster, you are the petitioners here, and go first. Go ahead.
Thank you. So the reason why we're asking for this order, we did provide quite a few, statements with the petition to begin with. But basically, we've lived in our house for maybe 6 or 7 years. During that period, we never had a problem with our neighbor at all. We even, I would babysit her kid. Basically, they would, her kid would come with me to work, hang out with my boys. We never had any problems at all. I became mayor of the town of Bucota about a year ago now. And since then, the town has had some, in my mayoral or work type duties, the town has had some issues that required my neighbor Danielle's water to be turned off due to lack of payment. There's no way that I personally can turn her water back on, but it's gotten to the point where, we've had a 2-week reprieve, which has been really nice, but I haven't even been able to go out. My son will go out to the car, and if Danielle's out there, she will yell derogatory things, and we've submitted evidence from our recording, our cameras, showing that, we can't go outside without her yelling at us, basically, and it's all really inappropriate things that my son shouldn't have to hear me be called, my husband be called, and all while I can't change what the town has decided to do based off of, my neighbor's actions. So that's why we are requesting for my husband, me, and my son the no contact order.
Okay, and I did read that in your petition and the documents you submitted in support of that, and mostly in the form of texts. I think there was one video and a image as well. Okay, is there anything else from either of you?
No,
you said it all.
All right, then, Ms. Johnson, it's your turn to tell me your side of it. I don't think you submitted anything in writing, so just, this is your chance to tell me your side of it. And you're currently muted.
Okay, sorry about that. So I just want to say that first of all, the last name is not Johnson, which they have filed it under, and I would like to say that the reason I contacted her on her personal phone was because I've gone to the town hall and they've told me that they can't help me or to call their lawyer, but they won't give me the lawyer's name. And when it was a hot day, I have the right to ask that my water be turned on, as well as my water has been paid now. And I'm not even allowed to go down to the town hall because it's where she works. But my problem with the whole situation here is in her statement, it states that that she was out walking and my husband pulled a gun on her. And my husband's been incarcerated in Eastern Washington since February of 2024. His DOC number is 745-862. So that whole situation there is irrelevant. And I'm fighting a foreclosure right now that was illegal. I'm going through a lot of things right now, and not having water and this whole situation is not, it's not all right. I have a child in the home, and it's not right. And I can't even pay it. They won't even let me pay whatever's left on it. So, yeah. And I've never said anything directly to them or said, hey, this person or that person. I mean, I could have been talking to anybody. Never directly to them did I say anything, other than when I asked her to turn my water back on when it was hot, and asked her why she went down to the neighbor's house and asked them to call CPS on me. But that's all I have to say.
Okay. Do you prefer to be called Miss Brown then?
Yeah, that is my legal name. And
okay. All right. Thank you. All right. Well, in a case like this, I need to decide whether I'm persuaded by a preponderance of the evidence that harassment has occurred. And, generally harassment's a course of conduct that's directed at a specific person that is harmful to that person, that seriously annoys or alarms or harms them in their mental or physical well-being, and it doesn't serve any lawful purpose. And that any harm that the person suffers is what a reasonable person under those circumstances would suffer. And so, I'm going to take into account the fact that the petitioner here holds a political office, and that people who are in political office are expected to have to deal with constituents who might not be happy with them. And there might be, heated words. There might be things said that are, pointed and sharp and critical. And that's all part of what it means to occupy a public position sometimes, especially one, a political one. And so that's certainly something that comes with the territory, so to speak. But on the other hand, there are lines and boundaries. And so even if a person is in a political position and they're just out living their lives and running their own business and doing the normal things that anyone would do, and then being subject to, basically being accosted on the street or accosted outside of the confines of their job and berated or, threatened or tormented, especially about official business. I mean, this business with whether the water is shut off or not is an administrative act that is done in a proprietary capacity by the city utility. And then focusing in on the mayor because the mayor is just the most obvious person who represents the city, and then getting, in a position to torment her in her off hours and make her, I can't see this as anything other than an attempt to intimidate her to get the water turned back on, which is happening apparently because you don't qualify to have your water turned back on by the normal process. And that's not okay. That isn't okay to do to anyone in a political position. Even though, as I said, people in a political position are expected to kind of have a tough skin and take a lot of criticism more than probably the average person. But that's not what this is. This is unreasonable. It's not something that a person in a political position should have to tolerate, especially because it's clearly being done as an act of retaliation for administrative acts that are done by the city. And so I do find by preponderance of the evidence that harassment has been proven here, and I am going to issue an anti-harassment order, which I believe will be like the temporary order that was issued a couple of weeks ago. In other words, the provisions of that would be the same. All right, so that'll be my ruling. I'm going to commit that to writing, and then both of you are going to get copies of this order. I'm sorry, who was that?
That was me. I was just,
Yes.
she works at the town hall, so I can't go down there.
I'm going to address that separately, so just hang on. All right, now I've issued this anti-harassment order that's going to be effective through June 30th of next year. And Ms. Brown, to address your concerns, which I think are legitimate, I've made an exception in the order to the exclusion provision, which is in paragraph 8D of the order, that the respondent, that's you, Ms. Brown, may conduct business and attend meetings at Bucota Town Hall.
Okay.
All right, that's the order of the court. The court clerk will send copies to both of you for the end of the day.
Thanks.
Thank you.
Thank you.
You're welcome. All right, next case will be Beach versus Belt, 25-189. And you are Miss?
I'm Levada Beach.
You're Miss Beach.
Yes,
Okay.
correct.
And then Miss Belt, there you are on the screen. And can you hear me okay, Miss Belt?
Yes, all right, I can.
Very good. Okay, just a moment here while I open up my file. Yes, okay, so Miss Belt, I see that you were served with notice of the hearing and a copy of the petition.
Yes, sir.
Are you ready? You ready to go ahead with your hearing today?
Yes, sir.
Okay, very good. So just like the last case, I'll swear the parties in and we'll get started. So can you each raise your right hand, please? And do you swear the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Yes, sir.
Okay, all right, and Ms. Beach, you're the petitioner in this case, so you can go first.
I pretty much put it down as clear as I could. I just would like to have the restraint order to cut any access of interference or threats from her or intimidation or games. I don't want any more to do with it.
So I'm just reminding myself of the allegations in the petition, and I mean, it's not clear to me what part of this sort of series of interactions is harassing to you. I mean, What's the part of
Um,
this that's causing
The
you
part
problems?
of her contacting men that I am seeing that she absolutely does not know and engages in conversation, which has been verified. I've spoken to them or to him, and he implied that he thought it was his cousin. The other part was she actually sat and described exactly how she was going to have my son put down to my face. And I was appalled. Um, I've never had anybody do that to me before. I am aware that her is not well. That was part of how this conversation was brought up. She had never met me before, but spoken to me once on the phone. It was not a pleasant conversation. I had reminded her of this when I was at her house. I was trying to befriend her, get to know her. I have only been in her home and engaged in conversation with her 4 different times. But in the short time that I have interact with her, I hope I'm saying this right. I can see why her daughter has fear. And I don't want any part of it.
Okay. Is there anything else I need to know?
No.
All right, Ms. Bill, I'm
Yes.
going to hear from you. And I also, I read the petition that Mitch Beach filed, so I guess I have a little familiarity with that, but I don't think you filed anything in response. So it's your chance to tell me your side of it.
Okay, so I didn't file anything in response because she has only been to my house once, and that was for maybe 10 minutes when her son and my son, were outside while my son was riding his bike. I very, very little spoke with her because I just don't have anything to say to her. As far as her saying I harass her, I don't have her friends on Facebook where I'm not friends with her son or my daughter. I don't have her phone number, his phone number, and I've blocked my daughter's phone number. So, and I don't even know where they live. And I don't know who this person is that she is speaking of that said he thought he was my cousin. I'm a recluse. I don't know anybody. I work and I take care of a drug addicted baby that was abandoned 8 years ago, who I have full custody of with, yeah. So I don't understand. I mean, what she's like, when I got these papers, I'm sorry. I don't know how to say this politely, but I felt dumbfounded and just dumbed down because I didn't understand any of the wording that she put on here because none of it made any sense because none of it's true. I don't have people like that in my life. I don't, yeah, it's ridiculous. I don't deal with her son because her son has his own addictions and I don't want that around my son, nor do I want my daughter's addictions around here. So that's why my daughter and her daughter went to Leveda's, I guess. But as far as anything of this nature, no, it's all completely false allegations.
All right. Anything else I need to know?
No, that's it.
Okay. All right. Thank you. All right. In this case, the fact is I don't see harassment here. I don't see that harassment's been proved in any way. I don't think any of the elements of harassment are met, certainly not by a preponderance of the evidence. So I'm not granting an anti-harassment order here.
So who do I do for protection?
If you feel like your safety is at risk, then you should call 911.
Thank you.
I signed an order consistent with the ruling that I just gave, and both parties will be sent copies of this by the end of the day.
Thank you.
Thank you.
Thank you.
Have a nice day.
This next case is going to be Meyer versus Adams. So Ms. Meyer and Ms. Adams, right? Okay. I've got two cases with you both here. So in the first one, Ms. Meyer has asked for a contempt finding for violations of a previously granted order. And then it looks like Ms. Adams has filed her own independent petition subsequent to that. And the hearing on that is set for today. I'm going to handle these kind of at the same time since you're both here. So I'll just hear what you both have to say and make a decision on both issues, the contempt issue that's been raised and on whether or not there's going to be an additional order granted. Okay, makes sense?
Yep.
Okay. The contempt issue is a little bit different than the hearings that you've seen happen up to now this morning, but it's also similar. So just sort of to frame that up, Ms. Meyer has brought allegations that Ms. Adams has engaged in conduct that violates the restraint provisions of the anti-harassment order that was issued earlier. And she's asking the court to make a finding that that occurred and to issue a contempt order. So that's a little bit different than granting an order, but the standards of proof are basically the same. So, all right, I'm going to have both of you raise your right hands, please. Do you each swear that the testimony you give in these matters will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
All right, so I'm Ms. Myers. I'm going to let Ms. Meyer. I'm going to let you go first.
Okay. So I had filed a anti-harassment, I want to say it was like May 19th now, and I had it granted. And since like right after that, a lot of things escalated to the point where I've had to talk to my landlord and I've had to call law enforcement. Law enforcement has been a bit harder because when I've contacted them, they've told me several times that my anti-harassment order wasn't served. So then I've had to call the court to get it to like verify to say like the law enforcement is saying that my anti-harassment isn't served and they're telling me it has been served, we have sent it. So then they've had to contact law enforcement again to say like this has been served, and then I've had to call law enforcement to like confirm and say the court has called you and sent you that this anti-harassment has been served. And because that was such an issue for me to even get like figured out, there have been multiple times where Cindy has violated my anti-harassment. And according to the cops, each time that I call them is a isolated time. So it's like I can't refer to it again. So it's like something has happened and I've had it on video where she's contacted me like directly. I can't like call them again and say like now can you help me because of my anti-harassment. It's been more along the lines of them coming and say like first they were like you need to get video proof because it was more verbal. So I understood that. I was like okay then. So then I would have video and then they would say well, now I don't have anything here that says that your anti-harassment served. So it's just kind of been an ongoing thing. So like the next step, I talked to a lawyer. The next step was like contempt, and they said just to give the information that I had. There have been incidents where she's yelling and screaming outside my door to the landlord, and I had a video of that, but the lawyer said because it wasn't directed at me not to that it wouldn't be something would that I could show the court, but I wanted to show it just because I wanted you to hear like how she talks and how she's screaming at like someone, even the landlord. And there have just been like situations where the maintenance, even my landlord has come to me and said that she said these things about them to the point where I'm like, that's how it is for me, where she's doing harassment to me directly. In the evidence that I sent you, there's videos, or not videos, of also photos of her trying to break into the laundry room where the knob and the lock have been completely broken out. And I've called the landlord and he's even verbalized and said, oh, she told me she was going to do this and I can't believe that she did it. And so then he took access of the laundry room from her because she messed with the like construction of the vent, and she's like screwing things, and so he took that away from her, and I feel like that kind of escalated it, but mostly it's been just about me, my home. I feel like anxious even being here. My landlord has given me keys to another property that he has, that when I'm not feeling safe, I could stay there. I can't live there because it's the property he's selling, but he has given me keys because he knows I have my son and he knows how like unstable she is because he doesn't want me to be around it. Um, it's been like an ongoing thing. The landlord has verbalized to me that he is working on like an eviction because even this harassment has gone to the point to him as well, because this has nothing to like pertain to my case, but I just want to say it because it also like shows her unstable behaviors, because he came to me after talking to her and said that she's implying to him that that she was going to say that he touched her inappropriately when he didn't. So it's just been like an ongoing thing all the way around. And for me, it's just been like I'm trying to keep my son in a stable and safe environment. Luckily, all the times that she's done stuff, my son has not been present. And I've been able to have him with his dad, or I've been able to have him at that property just to make sure that he's not here when she's like yelling or there's something going on or the cops are here. But it's been like a situation where it's just caused so much anxiety, and I don't even feel like calm or safe like in my home. So it's mostly about like having my son here. And I feel like in the last month and a half, he has barely even been here because I don't want him around this environment.
All right, well, let me hear from you, Mrs. Adams, both on the issues that Ms. Myers brought up about potentially violating the order and about your own petition for an order against Ms. Myers.
Could I ask you first, because I did go over the what was filed on both the cases last night, and I didn't see the police reports. Did you see any of that? Because that's kind of like what I'd like to focus on, if I may. I can provide you with a copy so we could follow along a little bit, and I'll try to go through this pretty quickly.
These are police reports?
Yeah.
Okay.
Welcome.
Have you given those to Ms. Meyer?
Yes, it's it's all been.
Let me see what you have here.
It's all been filed. I highlighted.
You might have filed those. I've got two cases I've got to take
Yeah,
a
I
look
didn't
at
see
here.
it myself, and I searched and searched, and I didn't see videos of where she's saying I contacted her directly, which I haven't, and the landlord verified that I had not as well in one of the conversations with Officer Paul. I just would like to go over each one of these a little
These
bit
are
briefly.
Lacey police reports. All right, let's see. Ms. Meyer, did you get these Lacey police reports? Well, they're not really police reports. They're abstracts of
Yeah, I've
calls.
seen I seen like
Cats.
I seen like some of them. I didn't really it didn't I mean it's showing that like the police officers came here and like verbalized, but it's not showing, I'm not really understanding like how that really pertains to like me, because I mean it pertains to me, but I just don't, I read them, but I'm not really seeing like.
Well, my question isn't whether you agree with them
Oh,
or think
okay.
there's any merit to them, just whether you know about them. Have you
Yeah,
had notice of these?
I seen the
Yeah.
ones that are in the documents that she served me.
Okay. So yes, you did file these. They're in your petition, and now I've found them. So, okay, mystery solved.
I have extra copies.
Yeah, no, that's fine. I mean, I appreciate
Were you
that.
able to go over them, or we could go
Yeah,
over?
these are just CAD logs. These are recordings that the 911 center makes that sort of outline the basis of the call and who responded, and sort of like a skeleton version of events, and then the disposition. So yeah, they're not really police reports so much as they're just sort of documentation of contacts and actions taken by law enforcement, taken by the 911 dispatch center at TCOM. So yeah, I'm very familiar with these. I know exactly what they are.
I'd like to be a little more specific on the charges or the accusations. So Bianca was granted a protection order on May 19th, and May 24th, it started with her calling the police. Yeah, I was doing my laundry and I did it up till midnight. But she called dispatch and told them I was yelling and pounding outside. And the officer came and she said she had a video of me making excessive noise. And I was just doing my laundry, and he listened to the video, and he made a comment here that that there was nothing unusual about, that he could barely hear on her video of me opening and closing the machines. He also noted that there was no sign of malicious intent. Basically, what I perceive is happening here now is because this went on for a week. It was every single day. I would go to the store and I come home and I was greeted by two police officers at the end of my driveway over the knob in the laundry room. The day after, or I think it was the day after the next day, she was so upset about Officer Gutierrez not arresting me because I was taking so long to do my laundry, that the next day in the report that's I'd use the last three numbers of the police event 020, she called him. She called and got him. He was working at the time, Officer Gutierrez, same officer that came out and demanded. It says she demanded that I have have Cindy arrested. And then he goes on to say, then and he just responded that she was just doing her laundry, and that he doesn't hear anything on the video of anything but that. And then she wanted to speak to his supervisor. It seems to me that he was, I can't say how another person feels, but he went on the next page to that and said he's going to write a report and refer it to the prosecutor because of not my actions, but her actions, demanding that he have me arrested for doing my laundry late at night, which is not uncommon for either one of us. We live in an odd situation with the houses that's been divided up into a duplex. Then let me see. So the thing with the vent, I mean, she's gone so far as to accuse me of there's a vent, it's a hole in the laundry room, and she's gone so far as to say that I took the vent off and I was peering through her house while she's sleeping on the couch, and she just suddenly wakes up and sees me staring at her. I mean, I don't even know what to say about that. I did try to cover the vent because the officer had told, I'm sorry if I get a little loud. I get a little loud when I get upset. But the officer had told me she was using the vent that goes into the laundry room. It is on the other side of her wall is a kitchen. And unfortunately for her, that the laundry room is she could hear the sounds more into her kitchen than the way the house is situated. I'm further back, so I don't hear it as much. Occasionally I do, but if the buzzer or something, but for her, you could hear it. So, I mean, it was twofold or more than that I even covered it up, but she didn't like the idea that I covered it up. I covered that vent up because she was using it to videotape me. You know, this is the privacy of my home, even though we shared the laundry room. She went so far as to have her friend Tristan Chapin come over and tear off the frame of the door, which is the door to my entrance into the laundry room. Hers is from her kitchen. We have separate doors. And that door has a lock on my side, keeping her from entering my unit and me vice versa. So her not liking that I took so long to do my laundry and whatever she thinks she went on to say I was harassing her because I'd taken so long. I was washing everything. But mostly because the officer wouldn't arrest me the next day for that she went so far as to have called her friend over and he tore the door frame off on this side and used it of my door and used it to board up the door so I couldn't gain entrance into the laundry room. In the meantime, it was anyway, we talked about the vent thing. So there was a point so I was texting the landlord and he said that he would, because the landlord did come over at some point. He came over and him and I, as soon as he pulled up, she comes running out. I'm by my car. I'm walking out the door, but I'm still by my car. And I have not made any contact with her whatsoever. I have done my best not to. She has tried to antagonize me. She has tried to coerce me into situations to talk to her. I don't even know why she has a protection order. The very next day, this happened on Saturday with the laundry. The very next day on Sunday, I'm out washing she has a garbage can as she assigned me this garbage can and she has this one. And I'm cleaning my garbage can. This was the very next day. It only took her 4 days to take that protection order and use it to harm me with, and I knew that she would. So I'm out I'm cleaning my garbage can out and I'm washing my car. And she comes out, she pretends to she's going to put something in her trash like this. And then she walks over, and it's so petty, it's ridiculous. She walks over, and she's looking at me, and I'm standing by my car, and I'm getting ready to wash my car because I rinsed out the can, but I have some trash next to the can because I was still working on that. And she walks over, she looks at me, and she grabs she is like this. And she's watching me the whole time, and she grabs the tip of the garbage bag and goes like this. And like as if there's this invisible line and don't cross it on the gravel. So for somebody that's so fearful of me, why are you putting yourself in harm's way? If I'm such you think I'm going to do something, but you come out and you stand there, you're not 10 feet from me. She did the same thing with her son. She sent her son out to play ball in the driveway, and I've lived there for 15 months now, and she's lived there a couple months longer. And the situation is the house has been divided, and I'm in the back, and she's up here in the front. And the driveway is, yes, she uses it because she has a parking space here, but I mainly use it because I have to go here, and nobody is allowed to park in the driveway. It was stated from the beginning by the landlord, though she had tried to do that at the beginning, and she has not done it since. Once I told her I don't want to be blocked in, but that went on to another story here. But so I felt she said, from what I could tell, I hear her son out bouncing the ball in the driveway, and I'm inside, and I'm not going to go outside because the protection order has his name on it too. And so I have a window right there. And so the curtain's open a little bit. And I noticed her cat was laying in a planter box, which, I don't care about the cat, that's what they want to do. And so I saw the boy and he waved at me. And one thing, he's never played out there in the 15 months I've been there. And he's never waved to me. And so, but I could tell he was about 10 feet behind my car. And so she has this little strip of sidewalk. And I could tell by the way he was acting, he was taking his orders, I don't want to say orders, but instructions of how to act with me, because he would look over her and then look over. I couldn't see her, but you could tell when somebody's interacting with somebody else. And so, but for him to wave, because I felt that she told him to go out there, and actually, I know this sounds a little bit crazy, but to wave at me because she's calling the police every single day over petty stuff. And they're saying she hasn't violated her order. She's calling the police back and saying, well, what does she got to do to violate her order? Can I help her? She's trying to help me violate the order. That's where the coercion comes in. And as far as cars, this picture part, she had her friend parked right behind me at 9 o'clock at night. I want to go to the store before they close. And she's saying, and yes, I did honk to have her come out. She never did come out, and police had to come, but the police are, so what I believe is happening here is she is using the courts to try to to get me arrested and to turn around, and because the police are saying she hasn't done anything wrong. There's no intent. There's 3 times for sure in these police reports that the police are saying no. So she says, oh, well, okay, I can't get them to do it. Maybe I can get the judge to do it. And then by that, she's going to go back and she's going to tell the landlord, okay, he's going to have her arrested. Now let's get her evicted. And it even mentions that she had that conversation with a police officer getting her evicted. She's telling them, she's telling the police, it's all written in here. She's telling the police what she's going to do. I'm going to make it. She tells one police, I'm going to make it where she doesn't have access to the laundry room. She's telling them beforehand, and they said, I'm going to make it where she gets evicted. So that's suggestive to everything that's been going on. For that last week. I mean, this has been going on a little bit longer.
All right, I understand.
Okay. And I apologize. I am very nervous, and I feel like I'm in lockdown in my house. I've been scared to death. I talk to my daughter about it all the time. I talk to my brother who lives in Florida about it all the time. And I've got my curtains closed. I'm afraid to go out in my car, and she's got, watching me all the time. And anything that she has, I'm gonna lower my voice, anything that you may have read in there, because I have gone over some things, she has submitted, she says videos, and my restraining order, though it's temporary, and I'm seeking a more permanent one, says that she cannot continue to videotape me. Well, but she keeps saying I'm videotaping her. So anything that she has presented to the court that's you're reading about, I've looked at the dates that she's talking about, and they're before my restraining order of May 19th. But she's what I see her doing too is misleading. She's misleading the police. She's lied to Officer Paul, saying that I made contact. I looked for that video. She was saying that I made direct contact. I want to see that. Anyway, I have said, no, right. I have not made direct contact. I have tried to avoid her.
Like I said, I understand, and I think you're kind of hitting the point where you're repeating things that you've already said, and so it might be time to stop here. All right, I'm going to tell you my ruling on both things. First of all, the contempt on the 25-133. I don't think contempt has been proved here. There's not a substantial basis to find factually that there were intentional violations of the order. I went back and reviewed the order, and the prohibitions have not been violated as far as what I can find here based on the filings and based on the testimony. Not satisfied by a preponderance of the evidence that occurred. So I'm going to deny the motion for contempt. And then the petition under 25-160 to issue an order basically in the other direction. I'm going to deny that as well. I know that there's difficulties introduced into this relationship by the fact that an anti-harassment order exists, but a person making reports of violations of an order and calling the police is not going to serve as the basis for harassment. So Ms. Adams, I'm not going to do that. Now, you have the right, Ms. Adams, to request the court by filing a motion to do this, to review or rescind the order that was issued on May 19th. That's not before the court right now, so I'm not making any rulings on that.
No, could you tell me again why you're not? Your Honor,
Because you
she's
have
not
to-
gonna leave me alone. I've been a nervous wreck. I can't take anymore. I want her to stay on her side and I will stay on my side. Please don't talk to me. Don't have nothing to do with me. Now I have to go out to the laundromat all the time. I have a broken wrist that's still trying to heal. And to have to lift all of the laundry, it costs $150 a month, which the landlord is having to pay because of her selfishness. But Your Honor, if I don't have, because she has the restraining order, so she has or thinks she has the upper hand. I don't know how I've not proven that she has not harassed me since she got that restraining order. She's going to keep coming after me. So what is it I didn't prove?
You have to prove by preponderance of the evidence that harassment occurred, and that has not been done, particularly by showing that she's attempted to have the anti-harassment order enforced. You find that disagreeable, but that doesn't serve as the basis to prove that she's engaged in a pattern of harassment. That is
calling the police on me every single day. Calling the police on me every single day is not harassment.
Now, like I said, the order itself, the order that was issued earlier, I believe that by Judge Meyer, you can ask the judge to review that if it's having consequences that he needs to be aware of to make modifications to the order. If you file a motion like that, the court may very well consider it.
Let me write that down. Okay, tell me again so I can write down because I'm not going to remember it. And directly to him?
No, to the court.
But not. Okay, what do I say now?
I'm not going to tell you what to say.
No,
I'm just
I know.
telling you that there is a procedure by which you can ask the court to review an order that's been issued and make modifications to it. You just have to make the request and support it in writing, and the judge will determine whether that merits a hearing.
So, well, I don't know why I'm not getting this. Review an order that's been issued. I don't have an order now. It's my temporary order.
The order that was issued in 25-133, the one that restricts you. If
Right.
those restrictions are causing you problems, you can ask the judge to review that. Okay. All right, so I've denied the order under 160. I've denied the contempt under 133. There are no written findings to accompany the denial of contempt under 133. That's done on the record orally. There's a written motion denying the petition under 160.
Your Honor, can I say something?
All right, what would you like to say?
There was also another order that she tried to serve on me that was a not the anti-harassment that she was trying to serve on me. There's another one where she tried to serve like contempt. Is that also getting dismissed? Because she's saying that
I don't have that in front of me for a hearing, so I don't know what you're referring to, but the only action that's been taken is what I referred to.
Okay. Okay.
All right, Ms. Adams, these are your copies here. And that'll conclude your hearings for today.
Okay.
This is 24-201. Okay, and as I said earlier, but you weren't here to hear that, Mr. Simmons, this is Mr. Huffman's motion to renew the previously granted anti-harassment order that's set to expire here in a little more than a week. So Mr. Huffman's asking the court to extend that order in its current form for longer. So before I go any further with that, Mr. Simmons, do you have any objection if the court were to extend that order for longer?
Yeah, I should have been the one that been granted an order against him. Him and all the surrounding neighbors that live around me, they're constantly harassing me. since day one, since I moved in 5 years ago.
All right,
I'm a targeted individual.
Let's refocus here a little bit, Mr. Simmons. I need you to understand the court's not reviewing whether that order should have been issued in the first place. That is a hearing that's been held, done, and decided. That's all in the past. So that's a closed issue. It's done. The issue is the court going to extend that order any further than July 8th? That's the issue before the court.
I hope not.
And so I'm asking you if you care if it's extended or not, and it sounds like you do. So
Yeah.
the burden, it's a little bit different than an initial petition or these other cases that you've heard today. There's a presumption that the order will be renewed unless the respondent, that's you, Mr. Simmons, shows by a preponderance of the evidence that acts of harassment are unlikely to occur in the future. So since that burden's on you, Mr. Simmons, I'm going to hear from you first, and then if necessary, I'll hear from Mr. Huffman. So can I have you both raise your right hands, please? And Mr. Simmons, do both of you swear that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? I do. Okay, Mr.
Yes.
Simmons, on the issue of whether the order should be extended for additional time, what would you like to tell me?
I don't find it necessary. And I would like to be able to go in that direction down that street because I'm an outdoorsman and I'd like just to have access to the mountain there. And with that in place, I can't. I used to be a cyclist and I'd like to be able just to ride my bike up and down the road, and we live on a dead end road and I can't even do that. But
which road is that?
I'm not a person. It's Fennel Road.
That's a dead end road?
Yeah, it just runs into a dirt road which goes into the mountains.
Oh, I see. Okay.
But it's
so tell me why it is
I'm
you can't
a laid
go
back
down that
person.
road. I don't just from the face of it, I don't
Because
understand why that's a problem.
Because the restraining order says I can't come within 100 feet from his house, and his house is right next to the road.
Oh, I see. Okay.
Yeah.
Yeah, I see that.
I don't want no problems with anybody. That's the last thing I want.
Okay, so that 100-foot restriction prevents you from going down to the end of the road. Is that what you're telling me?
Yes, sir.
Okay. Let's see what that order currently says. Oh, there. Yeah, it says 100 feet from the protected person's residence. Okay, I understand. All right, Mr. Simmons, did you want to tell me anything else?
No, that's basically it. I never wanted to have any problems whatsoever, and it's unfortunate that it's been like this. But other than that, just having access to go to the end of the road would be nice.
All right, let me hear from you, Mr. Huffman.
Okay, so if he didn't want to have any issues, he shouldn't be yelling at his neighbors from his property to get them to engage him. Like he'll yell at us, like if my wife or my daughter's calling the dogs, he'll mock them to try to get us to engage. I was out in the yard doing yard work and he heard my music and he'll start, like mocking it, trying to get us to engage. That happened before last year.
That's not true.
That's when he shot me in the ass with the slingshot. And now within the last month, maybe 2 months, we've heard arms fire.
Mr. Simmons, don't interrupt, okay?
Come from his property.
I'm sorry.
So now that seems as though it's not feasible, not accurate, or something he should have. And then my other neighbor that's on the other side of him walks her dog up and down the road. And when she heard him firing, she did not feel comfortable enough to pass by his driveway. So she stopped in front of my driveway, which I have on video, called her husband to come pick her up because she didn't want to walk in front of his driveway. So now it's to the point where it's gone from a slingshot. Now he has a small arm, a small caliber aiming, or a small caliber gun.
Okay. I'm going to allow this order to be extended for another year. I think it's necessary to keep the peace and for Mr. Huffman to maintain the protections he's had under this order. All right, I've extended the order, same terms and conditions as the original order until July 8th of 2026. And the court clerk will provide copies of that to both parties before the end of the day.
Hello. TNA District Court for County of Washington, State of Michigan is now in session. All those kinds of business reported on there. The Honorable Judge J. Cedric Simpson presides. You may be seated. You don't have to sit down, but you may. You know, I got, we go find her. You gonna go find Tana? Because I got Hawthorne here. He don't know what he's doing. Lowe doesn't know the court rule.
I'm ready to go, Your Honor.
Yeah, I know. It's all set over here. That side looks a little bit discombobulated. I don't know.
Trying her best.
Well, Her Highness has arrived. All right. What'd you say?
Oh, the waiver. He's
Yes, I was waiting for the waiver and
we need some more training.
No, he heard it on both sides. I don't even, how do you not know it, Hawthorne?
Let's see how I do with it and then
Okay.
talk about not knowing it. I don't
All
know.
right, go ahead, Ms. Tanner.
Your Honor, at this time, the people of the state of Michigan move to waive any potential conflict between Your Honor, Honorable Court, and the Public Defender's Office. We do not believe a waiver exists. However,
A conflict exists, you mean?
a conflict exists.
Okay, go ahead. I'm sorry.
A waiver does exist, a conflict, no. But if one were to arise, Your Honor, we would waive it.
All right, very good. Ms. Pate, you know it, right?
I don't know, I screw it up all the time that I'm here.
You do, but go ahead.
I get through it though. Your Honor, Assistant Public Defender Natalie Pate, on behalf of the Public Defender's Office. Likewise, Your Honor, our office does not believe a conflict exists between our office and this honorable court, but if one were to wherefore arise, we would waive such a conflict.
Thank you, both. The court, for its part, also does not believe there's a conflict either under the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus Nicholas Cits.
Good afternoon, I'm Marie Tanhouse, the prosecuting attorney on behalf of the people.
Assistant Public Defender Natalie Pate on behalf of Mr. Bosnack, who should be present via Zoom.
Well, I have two folks.
Sam's not Mr. Bosnack.
No.
Bosnick? Is that how?
Yes, I'm here.
Yeah. Okay, I need a camera, please, sir.
It should be on. Yeah.
It may be covered.
It's off now. There it is.
How about now?
Yep, there he is. All the way from New Zealand.
Yes, Your Honor.
I see, I remember. I
Yes.
absolutely remember. Because I mispronounced his name and he's in New Zealand. That's how
Yeah, he is here. And I have discussed this matter both with my client as well as with Ms. Zenda. And we were hoping, me and my client, to set this case for final settlement conference. I do not anticipate it moving forward to jury selection. I did speak with Ms. Zenda regarding her thoughts on that. And if the court were to somehow agree, if you would allow him to appear via Zoom for an August final settlement conference. I have discussed that with my client, and that is what he wishes to do. I do understand that the court typically has, of course, final settlement conferences in person.
Yes.
And I will just add for the record, if this does play a role, this is a 2003 case. And of course, as Your Honor is aware, he does reside in New Zealand.
Well, really what I should do is make him come here and then take us back with him to New Zealand. That's really what I should do. But
For the record, the people would leave it to the court's discretion.
all right, thank you. What I will do then is I will set jury final settlement conference for
August 8th, 2025 at 9 a.m.
Okay, it is the 8th. August 8th, 2025, 9 a.m. Jury selection would be, if necessary, August 11th, 2025 at 8:30. What I'm going to do is I will mark the file in person, but then note that defendant I will permit to appear via Zoom under state circumstances. If for whatever reason, so that the parties would know, if for whatever reason it would need to go to trial, I would be setting the next dates, which would then be in October. Those would be in person, but the defendant's attendance would be mandatory at that point.
Absolutely, Your Honor.
Okay.
Thank you.
All right. Thank you.
Yeah.
Thank you, sir.
Thank you. And what are those dates for there?
August 8th.
Yep.
2025. That's at 9 a.m. That's the jury final settlement conference.
Yep.
I pair that up with the jury selection, understanding that it would not go because I'm allowing you to appear via Zoom at this point. Jury selection would be August 11th at 8.
The 11th at 8:30.
Yes, sir. So you have the 8th and the 11th.
And the 11th at 8:30.
Yes, sir.
And that's AM US time.
Yes, yes. Because I have no idea what time it is in New Zealand.
It's 5 a.m. right now.
Is it? Okay, 5 a.m. Are you still on our date? Because we're the what?
No,
30th?
I'm a day ahead. I'm on the 1st.
Yeah, that's what I thought. Okay.
Yep.
All righty, sir. You take care of yourself.
Great. Thank you so much. See you then.
Thank you, sir.
Court does call the case of the people versus Eric Buckner.
Good afternoon, Your Honor. Marie Tanha, Assistant Prosecuting Attorney on behalf of the people. And Assistant Public Defender Natalie Pay on behalf of Mr. Buckner. Your Honor, I have spoken with Mr. Buckner several times in anticipation of this court date, and he was aware that he was to appear in person. My latest update from him was that he texted me at 1:01 stating that he, split up, Your Honor, I apologize, that he is in the hospital. I asked for proof of his admission, and he responded that he was talking to a nurse and he would send some, but I still have not received any. That is my explanation for his failure to appear. I do understand the situation, but for the record, would respectfully request an adjournment of this hearing.
In your response to the people.
Your Honor, I think the court knows more about the background of this case than I do, but my understanding is he is supposed to be here in person.
Yes.
I also have grave concerns about the safety of the victim. I have reason to believe that he has been stalking her, which would be no surprise given the background of this case. Given those concerns, Your Honor, I would ask for a warrant with a high surety bond.
What I will do in this case is I'll issue a bench warrant for the defendant's failure to appear. I'll set bond in this case in the amount of $15,000 cash surety is paid, if there is information that comes through, then the court won't have a problem necessarily setting it aside.
Absolutely, Your Honor.
All right, that warrant will issue immediately. Thank you. Court does call the case, People versus Douglas Lee. Uh-oh. Uh-oh. Hold on, slow down. Just slow down. Let's get it right.
Requesting permission to practice pursuant to Michigan Court Rule 8.120. Under the supervision of Assistant Prosecuting Attorney Maria Tan.
Permission to practice is granted.
Hello for the people.
An Assistant Public Defender, Natalie Pate, with and on behalf of Mr. Lee, who is present via Zoom. Sir, can you please unmute and state your name for the court?
Douglas Lee.
All right, thank you, sir.
Thank you, Your Honor. I have discussed this matter with my client, and at this time, he wishes to set the case for final settlement conference.
Jury final settlement conference, August 8th, 2025, 9 a.m. Jury selection, if necessary, August 11th, 2025, 8:30. Both of those proceedings are in person.
Yes, sir.
All right. Okay. Thank you.
Thank you, Your Honor. Thank you, Mr. Lee.
Excuse me. What date was that? Is that August 8th?
Yes.
August 8th for jury final settlement conference, and then the August 11th would be jury selection if it's needed.
Yes, sir. Yes, sir. Thank you.
Thank you. Found continued.
Thank you.
Court calls the case of the People versus Jaquil Lloyd.
Assistant Public Defender Natalie Pate, with and on behalf of Mr. Lloyd, who is present via Zoom. Sir, excuse me, can you please state your name for the court?
Yes, Jaquil Lloyd.
Thank you, Your Honor. As to the case itself, I have discussed this matter with my client.
Can you hear me?
I respect.
Yes, we can hear you.
Hello?
Hello, can you hear us?
Yes, now I can. Now I can, Your Honor. Now I can. Good afternoon,
All
Your
right.
Honor.
Good afternoon, sir. All right. You want jury final settlement conference?
Yes, please, Your Honor. And then if I may address an aspect as to bond briefly.
All right. Jury final settlement conference in this case will be set for August 8th, 2025 at 9 a.m. Jury selection, if necessary, August 11th, 2025 at 8:30. Both of those proceedings are in person. Yes, as to bond.
Thank you, Your Honor. So Ms. Perrine covered this hearing for me last week when it was in front of, or not last week, 2 weeks ago when it was last in front of Your Honor, rather. And I believe the request was made for Mr. Lloyd to discontinue testing. To my understanding, it was it was denied at that time just to see that his levels, I believe, of marijuana were coming down. It is my understanding he has not used since his arraignment. The allegations in this case do not involve any sort of alcohol or drug use of any kind. And I would ask, given my client's expenses to pay, he has to pay each time he tests, and having to come, he does not reside in Washtenaw County. He hasn't had any bond violations to my understanding, and we are just asking that the testing discontinue.
Yes. Send us a level. Is there a response from the people?
If one moment. As long as he's clean or the levels of marijuana are coming down, then we would have no objection.
All right. So, Mr. Lloyd, you're going to have to wait online. We're going to try to get those from Community Corrections. Hopefully we'll have them momentarily, and I'll call your case back up. Okay.
Okay, thank you.
Thank you.
Thank you, Your Honor.
Court does call the case of People versus William Fridge.
Mr. Fridge was scheduled before the court for a review hearing. He is compliant with the terms ordered by the court, and I did waive his appearance. Mr. Fridge did fail to appear for his last review hearing a couple weeks ago. Mr. Fridge was in contact with my office. I got him set up. He's working and got him set up with a payment plan that he can manage and has been reporting to me. Given that he's in compliance with that, probation is asking that the court indicate that he paid $125 per month beginning July 25th. He recently made a payment to the court, as noted, that he continue all of the terms as previously ordered, with the next review hearing date being set September 2nd, 2025 at 1 p.m.
And Ms. you're going to communicate this if I order it to him?
I already did, John.
You already did?
Yes.
Assuming that's what I was going to do.
Correct. I told him that was my recommendation. And he knows who makes the final call. Mr. Fritz does.
But nobody else does it seems.
Oh, he knows.
No.
He knows.
All right. The court will, without objection, order that the defendant pay $125 per month beginning July 25th, 2025. I'll continue all terms as previously ordered. I'll set his next review hearing September 22nd, 2025 at 1 p.m.
Thank you, Your Honor.
All right. While we await community corrections, court will stand in recess. Everybody can remain seated. Are we all set?
Yep, we are.
All right, we're back on the record in the case of the People versus Lloyd. Mr. Lloyd?
Yes. Yes, hello?
Yep, there you are. Okay, we received the results. Regrettably, you missed a test on June 25th.
I missed the test on June 25th.
Yes, sir.
I didn't know that.
Okay. Well, and your attorney, Ms. Pate, had indicated before we came back on the record, she was unaware of that also. It's unlikely that a violation, although I can't guarantee it, it's unlikely that a violation will be forthcoming, but you may want to contact community corrections to set up new testing.
Okay, today is my testing today. I'm actually on my way there now. Because today they called my name.
You're what?
I'm actually on my way to test right now. They called my name today, just now.
Did they? Okay. Yeah. So go over and get the test, and then your attorney can maybe file a motion with the court, but I'm not going to do anything on this today.
Okay, and I have another question too, Your Honor. When would I be able to first face my accuser?
Do what?
Mr. Lloyd, we discussed that on the phone. Your next court date is August 8th.
Oh, wait, you're right. I forgot. I'm sorry.
Got it?
Yep, I got it.
Good morning. We met before, but you're Martina Yvette Brinson?
Yes, sir.
You're with your lawyer, Mr. Paul Gibson. Miss Gibson, Miss Brinson, you and some others were caught stealing some property from a Walmart store in Three Rivers back on May 16th. However, I think you're the only one to actually get charged. I'm not sure if they ever figured out who the other people were. The original charge was retail fraud in the first degree, stealing property more than 200 as a second or subsequent offense, conspiracy with others, Tay and Teresa, to commit this, and then lying to a police officer as a third habitual offender. So there was a lot going on there. The matter was reduced to a retail fraud over 200, but less than 1,000, which is retail fraud second. You have an extensive theft history in Kalamazoo County, and you had a charge pending in Portage. So I continue the matter until today. I want to get the police report, and the prosecutor staff's always very helpful, and they got me that. So I don't know what to do. So Mr. Gibson, let's hear from you.
The defendant wants the court to know that she fully accepts responsibility for her actions, and she very much regrets the choices that she made. She understands the serious nature of this, and and she's committed to learning from this and moving forward in a positive direction. She indicates that in recent months, she's lost family members, her mother, her stepmother, her aunt. She's also facing potential homelessness as she's facing an eviction action. And so she's focused on trying to remain positive. She has a 16-year-old son who she indicates that she's also helping to support. She did indicate to me that she recently found a job. So if she was ordered to pay financial sanctions in this case, she believes she could try to make payments toward this. So
where's your job?
Doing costume parties.
Costume parties?
Uh-huh.
Okay. Sound like a real gig for much, but.
And so she's asking the court to potentially consider a sanction that would allow her to have a chance to try to pay off the debt from this. Thank you.
All right. This was professional theft. They came here to our Walmart store in Three Rivers, and this happens a lot. People come from other areas there specifically to steal stuff. You got these other ladies who we don't know who they are other than nicknames. What you got was a hoverboard, which was worth over $200. I'm not sure what it was they got.
Another hoverboard and a bicycle.
All right. So what were you gonna do with these hoverboards?
My grandkids.
All right. And I'm not exactly sure. But it was worth $98, so it was actually worth less than $200. And I believe it was recovered. Is that correct, Ms. Davis?
It was. This one was. The other one and the bicycle were in the other vehicle and were not recovered.
And I guess I can't paint her with that brush. What's the status of your portage charge?
I gotta pay fines and costs.
You pled guilty to that charge and they give you a fine?
Uh-huh. So I already had went to court for that.
All right. You had a court date coming up when I saw you the last time. So a $98 hoverboard that was recovered. The wrinkle is you got so much of a history of this sort of thing. And these other ladies all vanished into the wind, I guess. Are you on probation or parole?
No.
Or bond anywhere?
No.
Okay.
Just here.
Ms. Davis, what's your thought?
I guess I'm curious how old her grandkids are. If she's wanting to say.
Well, they said she had a son that's 16. How old are your grandkids?
I got 13 grandkids.
The ages are what has got me kind of perplexed here. She's 49 years old and she's claiming she's getting these electronics and a bicycle with these two other women from out of county for her grandkids. So these are items that are more likely just going to be sold on Facebook Marketplace or in the neighborhood or wherever. What also really bothers me is that the loss prevention officer who has been doing this for a while saw these individuals and suspected that something was going on. So he approached them. They accused him of being racist and then went and stole the items anyway. So it's like they knew that there was somebody watching them, but they're so brazen that they just went ahead with it anyway. And then she lied to the police officer about it. So as much as I sympathize with her personal situation with losing family members, that is awful, that is terrible. This situation is something that needs to stop happening. And we don't need more people coming down from out of county to steal from our local stores and use our local police resources to hunt them down, for their own personal gain. Even if it was for her grandchildren, it still doesn't make it right. It's not a necessity. It's something that, is a luxury item, I guess I'll say. And to me, with her long history, this deserves jail time. So I'd ask the court to place in jail.
People steal for different reasons. One of the most common things stolen in the day was cigarettes. You can't steal cigarettes anymore. People steal liquor. It's harder to steal it, particularly from Myers or Walmart. Myers liquor aisle has the security of Fort Knox. There's cameras all over it. People also steal things they can sell. Game controllers, electronic components that they don't steal them to steal them. They're stealing them because they can sell them. There's a big market in stolen power tools. Also, Home Depot is very lax on their retail fraud policies, but we've had a house with $10,000 worth of stolen power tools in it. Some guys from another county had thousands of dollars worth of stolen power tools. They were driving from Home Depot to Home Depot stealing the stuff. So I'm not sure what this is. A hoverboard worth $98 to come all the way down from Battle Creek with these ladies to here to steal. Then there's this confrontation with the officer, confrontation with the security guy, and you stole the stuff anyway. These other two ladies are apparently, like I said, in the wind. You know who they are. You're apparently going to take the hit for them. Retail fraud, third degree, 627.12. Retail fraud, second degree, 118.17. Retail fraud, third degree on 323.18. That's in Calhoun. Third degree retail fraud, April 26, 2018, Kalamazoo. Retail fraud, second degree, 513, 8th District Court, and the new retail fraud in Portage, 423.25. And so you were on bond from Portage when you came down here and did this one.
I wasn't on bond.
Oh, it was already done?
Mm-hmm.
Okay.
He dismissed that.
Okay.
I just had to pay fine.
We get a lot of this at Christmas where people are stealing Christmas presents because they can't afford them. But as Miss Davis said, this is not it's not like you're stealing food, but you won't do it down here anymore. I'm going to order 3 days in jail. You already spent one.
I'll see 4 days.
Within 4 days?
Yes.
Let me look at this. I didn't catch bond posted 5/15, 5/19. You got picked up on 5/16. And we're 5 days jail, credit 3, leaving 2 days to serve. Fine is 0. There's a $75 crime victims' rights fee, a $50 state minimum fee, and a $150 attorney fee. You're barred from all Walmarts. I don't want this to be an attractive place for people to come from elsewhere to steal here. I sometimes rail about being Walmart's security agency for their electronic scanning stuff, but this is an outright, people came here to steal. So you're gonna go to jail for a couple of days, then you'll get out. I'm gonna give you some time to pay the $275. You did post a $4,000 surety bond. But I'm gonna give you some time. I don't think I have any money there. No. I'm gonna give you until October 30th to pay $275. Right now, you just need to pay rent. All right, you can go with the court officer. He'll get out in a couple of days. Today is Monday. She'll get out Wednesday. All right, thank you.
I will grab it. Can you grab, or can I grab the bag?
All right, good luck, sir. I've got, all right, let's see who we've got here. Attorney Begg is here for the plaintiffs. Kathy Doyle is here. It's afternoon here, but good afternoon.
Yes, good afternoon.
It feels like morning. Kathy Doyle, how are you connected to this?
I'm on my cell phone.
But which case are you here on?
Oh, 1 second. It is 180951 GC.
Oh, yes, you're here for one of the 145 cases. You're in the right place, just a little early.
Oh, I apologize.
Oh, you don't need to apologize. Better to be early than late, and it's a public courtroom, so you can pretend you're sitting in here. I'm assuming I've got a Marion King and Brianna Guerrero. Is that Motorola?
Yes.
All right, let me give you a proper name. All right, let's talk about this case. It's file number 251243. It's entitled Sturgis Limited Housing versus Marion King and Brianna Guerrero. Attorney Jay Begg is here on behalf of the Stephen Gann Law Firm for Sturgis Limited Housing. The manager, Rebecca Wolf, is also present. Meg Bauer from Legal Aid is also here with us, and we always appreciate her being here if needed. This is a demand for non-payment of rent, and rent appears to be substantial, about $4,500 or more. We'll talk about that in a minute. Ms. King and Mr. Guerrero, you are defendants in a landlord-tenant proceeding. You have certain rights in that case. You have the right to have an attorney. You can hire one. Well, you have a right to hire one. You don't have a right to have one appointed. An attorney from Legal Aid may be available for consultation, and there is one here with us on the feed. You could also seek other legal consultation or advice if you wished. You have a right to have the matter heard here in St. Joseph County, where the property is located. That's where I'm located. You have a right to demand a jury trial. If you want a jury trial, you must tell the court at the first court appearance or make the demand in writing within 5 days of the court explaining it to you, which is today, using the jury demand court form, and be prepared to pay the $50 jury demand fee unless the judge waives the fee for inability to pay it. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, like in this case, you may be able to get some financial assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, a housing assessment and resource agency. In our county, that's Neighborhoods, Inc. Or if you're a veteran, you could be eligible for some veterans assistance. We sent that information to you with the original packet. You do not need a judgment against you to receive help from places listed above. A copy of the summons and complaint are sufficient, and you've already received that. You may be able to reach an agreement with the landlord that means the case would get settled But if that is done, they could file what's called a conditional order of dismissal. You also may be able to reach an agreement by going through mediation or community dispute resolution. If both parties are interested, you can advise the court and the court will help set that up if both parties are interested. All right, Mr. Begg, it looks like you're in a nice restaurant someplace. Let's see if we can get through this. This is a non-payment of rent. At the time of filing, rent was $4,520 in arrearage. The manager, Rebecca Wolf, is also present. So could either of you give me the current arrearage here?
Yeah, I will. It's rent to retain. There's $5,900, court costs, including statutory attorney fee, $288 for a total of $6,188. And this is both a possession and a money damages action.
They're asking you to move or pay the rent. They're also asking that I give them a money judgment. Tomorrow, another month's rent of $1,130 is going to be due. So this will, by the time we meet again, be almost $7,500. What's your position?
You talking to me?
Yes.
Well, I've been fighting unemployment since December, since I got fired, since I haven't paid the rent. We just had our last meeting with the judge last Monday, and it's still in progress. They have 10 days to make a decision. Wednesday will be the 10th day. So I checked this morning and it's still in progress. Which they owe me about as much as I owe in rent.
Well, what state is it?
In Michigan.
Where were you? Where was your job?
Adapt in Michigan, Sturgis.
All right, well, maybe the rent won't come through. The law requires that I adjourn this at least 7 days. So that takes us to next Monday, the 7th of July at 2:20. Are you available at that time, Mr. Vague?
If I'm not available, someone will be, so that's fine.
Yeah, your firm's got coverage. I appreciate that. Why they stuck you with this while you're on vacation, I don't know, but I appreciate your being here. So let's
I appreciate
talk about
you accommodating me.
There's a lot of money due. They're asking me to have you pay the money or move out, and then they're asking me to enter a judgment saying that you owe that amount of money. Which will be $7,300 or so by the time we get to next month. If you pay the rent, then you just get to stay there as you do. July's rent will be due, August rent will be due. So if you get a large infusion of money, you can pay it. Now, let me tell you something you need to know. The only thing that cures this is paying the entire amount. A partial payment will not prevent the writ of eviction. So if you get $6,000 and you owe $7,300, you have to pay the whole thing in order to cure it. So you might consider using that money to move with, but I'm also going to enter a money judgment if they get what they ask for, saying that you owe that amount of money. So if they do get what they ask for, you would have an additional 10 days from July 7th to move or be subject to being evicted. That would be July 17th. So we'll address this further. I appreciate the fact that you're here in a timely manner. I can hear you and see you both. Meg Bauer is here for consultation if needed, but this simply appears to be you lost your job, you stopped paying rent, you owe the rent. So it's in the old thing of pay or go, but we'll address it further. Hopefully it will come through and you can stay. Do you have any questions?
No, not at this time.
All right, the lights are flickering here. Hopefully the power won't go out. We've had a bunch of that this spring. All right, anything further, Mr. Bate?
Thank you, Judge. Appreciate it.
All right, I'll see you next. Now, you could also go in and talk to your manager, Miss Wolf, about perhaps making some sort of arrangement or something, but in the meantime, I will be here and I'll see you next week.
Okay.
All right, you're good to go.
All right, thank you.
All right, this is the part of the afternoon where I have to shift mindset. Let me remove some people from here.
I'll take it out.
People don't know how to leave. All right. We've got our next parties. We've got two matters. We've got Sturgis Hospital versus Kathy Doyle. Kathy Doyle is here and Robert Goodman is here on behalf of the hospital. We also have a motion to set aside a default in Lori Greenwich versus Tim Lotta and Samantha Lotta. We're going to take that one up first. We also have the alleged Andrew Rognus waiting. He has a case a little bit later this afternoon. I'm going to call this general civil case. It's entitled Lori Greenwich versus Tim and Samantha Lotta. This case is unpleasant and involves family members suing each other. I have about 6 pages of notes. I set this matter for trial after significant consultation. And then some other things transpired. The trial was set. I blocked out a whole bunch of time, I think a whole day, for May 30th. Mr. Buckland, who represented the defendants, Tim and Samantha Lotta, had indicated to the court that he lost all contact with his clients and they wouldn't return his messages, phone or email or otherwise. So he filed a motion to withdraw as counsel. And as the trial was nearing, that hearing was set for May 21st. So we had a hearing on May 21st, and Mr. Spencer was here, and the plaintiff was here, and Mr. Buckland was here, and the Lottas were not. So Mr. Buckland was allowed to withdraw as the attorney in this matter. But the trial was still set for May the 30th. Mr. Spencer had prepared his plaintiff's case. He was ready to proceed. But we didn't have any contact from the defendants. So I told Mr. Spencer that I would like him and his client to be here on May 30th, but he didn't have to have any other witnesses here. So he was here in Centerville, live in person. The plaintiff was here and the defendants didn't show up. They had previous notice of the May 30th trial date and they didn't come. We didn't know where they were or what the deal was. So I entered a judgment by default in the amount prayed for by the plaintiff. Money damages in the amount of $14,031.13. Court cost in the amount of $336 and an attorney fee of $3,486. And I granted a judgment in behalf of the plaintiff in that amount. So some time passed. That was on May 30th, that order entered. Mr. Lotta and Miss Lotta woke up from slumberland and have filed a motion to set aside the default.
No, we came to court and the power was out here.
That was on the 16th.
Yeah, and we never got anything
We
else.
never got anything else except for to tell us to be here on this day.
No, we got
that we lost or whatever. And I come in and filed that motion.
Yes, on Friday, the 16th of May, the power went out. I called Mr. Spencer. I came into the courthouse, used my cell phone, called Mr. Spencer and told him the power was out. I called Mr. Buckland and told him the power was out. But since he had no way to contact you, who was still at your time the attorney of record, I'm not sure what happened. So the motion to withdraw was set for May 21st. I don't know whether you knew about that, but you knew what the trial date was. You knew the trial date was May 30th. It had been set some time ago. You didn't show up on May 30th. So you filed a motion to set aside the default. And you have to show two things. You have to show good cause for why you did not appear, and you're supposed to file what's called a meritorious affidavit of defense. But you've got a long letter in here going into the facts.
I've never done this before, and I just did what the lady in the
Let me tell you this, I'm not very happy about this. He couldn't get a hold of you. We're chasing our tails around. We had the hearing to withdraw his counsel. Apparently you did show up on that date. I don't call individual defendants, I call their lawyers. In fact, I tried to call everybody I could get with just my cell phone. So anyway, you didn't show up for the motion. Maybe you didn't know about it, but because your lawyer couldn't get a hold of you, then you didn't show up for the trial. So why didn't you appear for the trial?
We've never been through anything like this, and I didn't know we needed to be here.
Oh. Okay. Why did you stop communicating with your lawyer?
We talked to him last time, and he said he was taking care of everything.
And then we got a letter saying that he wanted to withdraw.
Yeah, that's the only letter we've received. And a bill.
Yeah, and a bill.
Well, when you're sued, you got served with a lawsuit. You filed an answer with an attorney. I hope we don't lose power again. There are emergency lights in here, so it won't be in the pitch dark, but I set aside a whole day for this. They were here and you weren't. And I'm not sure that you've got a legitimate reason for not appearing, that you didn't know you were supposed to be here when you were sued. And I had given you the date of the trial in the courtroom. So I'm not sure. Mr. Spencer, you wish to speak to this? Your mic's on mute. I just unmuted it.
Can you hear me now, Judge?
Yes.
Okay, sorry about that. So, Your Honor, yes, I would concur. I mean, you have correctly stated that I think the Lattas have to show good cause for why they did not show up, and they have to be able to present a meritorious defense, which I don't think they're going to be able to do either, Your Honor. And frankly, the letter that they filed does not comply with the court rules. It's not in motion form. It is not verified per MCL 109 D3, Your Honor. And the bottom line is the court, if I recall, set this trial date of May 30th, I think back shortly after we had the hearing on the motion for summary disposition filed by the Lattas, which was on February 28th. And shortly after that time, the court contacted myself and Attorney Buckland, and we set this, the court set this matter for trial on May 30th. And so, frankly, the defendants have had well over 2 months' notice, Your Honor, probably closer to 2.5 months of when the trial date was. And they were not here, and they did not, as far as I'm aware, the court was not made aware of them trying to call in or anything, Your Honor. So I would just ask that the court deny their motion for setting aside the default judgment and allow the judgment to stand as entered back on May 30th.
I also have another question. Lori's used my address the whole time, so we had an Indiana attorney the whole time because the Indiana attorney said that she needed to sue us Indiana. She used our address in Indiana, and I brought all the proof. And then her daughter somebody said was gonna testify against us, but I brought all the letters where everybody in the family said that she's ripped everybody off, manipulated them, takes from them. I brought everything right here. I didn't know about the 30th. I wouldn't have missed it because this is driving me crazy and I'm ready to get it over with. I have affidavits here. I brought everything.
Yeah, proof that showed that she was at our address. It says 9 years.
Yeah,
But she's claiming she was in Poland.
Yeah.
So this was an Indiana matter. We're not sure why this is even here.
Yeah, our lawyer said that since she used our address, that she should be suing us in Indiana. This whole thing is a mess up. Like, I've never dealt with a mother ever, I'm sorry, doing this to children ever.
Yes, it is a family situation. Well, if you're denying a lawyer so smart, why didn't she file an appearance or make some comment down here? Jurisdiction committee, be at either end. It can be possibly in Indiana, it can possibly at this end. So you're taking advice from somebody that isn't here, hasn't filed an appearance, and
she just told us that her jurisdiction, she couldn't come here.
yes, she's not licensed to practice in Michigan. Your lawyer, Mr. Buckland, filed a motion for summary disposition saying that there were no material issue of facts. Judgment should enter for the defendant. That's fairly rare that the defendant files a motion for summary disposition. We had a hearing on February 28th, and I made a finding that there were a material issue of fact. And I denied the motion for summary disposition. We set the hearing for a motion to withdraw as counsel for the 16th of May, which was a Friday. The defendants, I'll take them at their word, they came here to the courthouse. It was a pretty nice day, actually. And nobody was here but the bailiff at the front door because all the lights were.
Couldn't even get paperwork for work developed that I was here, so.
He was super nice though, super nice guy.
All right, yeah, they are. So I reset the thing for the next available time because we're coming up on crunch time. We're coming up on this trial for the 30th. So you don't appear at the 21st, but it's your contention that didn't have notice.
Oh.
I do believe you had notice of the 30th. And your answer was you didn't know you needed to be here. And I don't think that's a legitimate reason for not appearing for your trial. I don't know what the breakdown between you and your lawyer, Mr. Buckland, was. He's got a good reputation. He does good work in my court. He tried to follow all the steps. He was frustrated that he couldn't get any response from you. We made a brief record on the 21st when I did allow him to withdraw. Mr. Spencer didn't have a position in it. He said, well, it's not up to me. And I was allowed to withdraw. So I don't think, I'm not sure whether there's a meritorious defense. You have this long letter and you have all these other allegations. As I said, there were material issue of fact, but I don't think there's good cause for not showing up for the hearing that I blocked out a whole day for. So I find that their good cause and a meritorious defense were not established. The motion to set aside the default is denied. Plaintiff opposes it. I don't know what we would have had if we had had a trial, if you had been here. But I was very frustrated. And I know Mr. Buckland was, and Mr. Spencer couldn't make any headway with Mr. Buckland because Mr. Buckland couldn't talk to you. So your motion is denied. And if you go out to the counter, you can get a copy of that. You can appeal that to the circuit court. This is a very unpleasant family situation, and there isn't any other way to put it. But the motion to set aside default is denied. Good cause not shown for failure to appear. You owe the money, which is the whole hard truth. Owing it, collecting it are two different things. All right, if you go out to the counter, you can get a copy of that order. Thank you.
And then how do I file for the other?
If you wish to appeal it, you can appeal it to the circuit court. And they'd have to show that I abused my discretion in denying your motion to set aside the default. You need a lawyer. I don't know why you let the lawyer go that you had, and your Indiana lawyer doesn't have any authority here, but you could use some legal advice to be sure. All right, Mr. Spencer, thank you.
Thank you, Judge. Have a good day.
Thank you. Andrew, have you seen that before where somebody gets put on their mother's account to assist and the garnishment then seizes those funds?
Yeah.
All right, well, let's talk about your landlord tenant case. Ms. Carter, I'm sorry, we're about 23 minutes behind, but all things considered, could be worse. This is file number 251369LT. It's entitled Carrie Sears versus Danette Carter and all others at 113 Rose Court, Sturgis. This is a termination of tenancy action under the emergency provision. There is apparently no lease, or if there is a lease, I don't have a copy of it. Mr. Rognus alleges damage, health hazard to the property. This property was subject to a search warrant and resulted in criminal charges against this defendant, Danette Carter, and several others, including the allegation that they were maintaining it as a drug house. So the landlord wants them to move out. Now, Ms. Carter, as a defendant in such a case, you have the following legal rights. You have the right to hire an attorney. If you cannot pay for one, the legal aid attorney may be available to help you. Meg Bauer is here, but she's presently talking to another client. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell me at this first court appearance or make the demand in writing within 5 days, explaining your right to the jury trial, and be prepared to pay the $50 jury demand unless the judge waives it for your inability to pay. If both parties are interested in mediation, the court can help set that up. There may be a reason to settle this with a conditional order of dismissal, meaning if both parties can agree, say on a move-out date or something, they could file a consent order of conditional dismissal that would take care of this matter. Your criminal case is file 25996FY. That charges delivery of methamphetamine and maintaining a drug house. That was in front of Judge Pattison. I think I did your initial arraignment. That matter is bound over to the circuit court on last week, June 16th, or a couple weeks ago. So, Mr. Rognus, your position is you wish the defendant to move?
Yes, Your Honor. By way of background, her co-defendant, Christopher Sears, is Carrie Sears' son. Christopher has now deeded the property back to his father, and we're taking heat from the City of Sturgis Police Department about all the drug activity that's taking place over there. Definitely want the property back so we can go in and rectify the circumstance. Substantial amount of rehab is going to need to take place. I don't know if you read all the police report, but it is in bad shape.
No, it's not.
And there is no lease. I mean, Ms. Carter was there just under the auspices of Christopher Sears, who nobody bailed out of jail because his dad's sick and tired of his meth habit.
I do have receipts of me paying rent though.
All right, well, Miss Carter, what's your position?
Right now, I moved in with Chris, because he said he needed help paying his rent, so I moved in with him. Back last, November of last year when he lived in Village Manor. And I have been paying him $500 a month, every month since then. I do have some, I do have some receipts, and right now, and the reason I was glad that he did let me move in, which was a blessing, is because I was homeless at the time, and when I leave here, I will be homeless again.
Well, you have no lease. The person that owns the house isn't getting any of the money. I don't suspect you're paying $500 a month to Christopher Sears when he's in jail. So you're what's known as a tenant at sufferance.
I paid rent last month, Your Honor. And I get paid. I paid Chris Sears $500 last month, and I'm on disability, so my next check isn't until the 3rd of this month.
All right, well, don't pay anybody anything. Chris Sears doesn't own this house. Carrie Sears owns it. And so I wouldn't pay Chris Sears 5 cents. I think he's in jail.
Correct.
Yes.
So you're there with no lease. The search warrant was very graphic. They contend that you're the one that's selling the drugs out of there, known as Mama D. Your matter's bound over to circuit court, and police are concerned about this place, and the man that owns the house wants you to move. Have you made any provision to try to move?
Right now I have been looking for a place to stay. However, I have had no luck. I do have a friend that is going to take me to House Inc. or whatever. They help with helping you find an apartment and stuff like that. And that's what I was going to be going to do tomorrow.
Neighborhoods Inc.?
Yes, I couldn't remember which one it was. They help you with an apartment or and things like that.
Pay the rent. Now, this isn't about paying the rent. Now, they filed this as a
unlawful drug activity case.
Yes.
Well,
is anybody else in the house?
No, it's just me and my cat. I have a friend here and there that'll come by and say hi, hang out for an hour or two, and then leave. I cleaned up the house pretty much. I cleaned up the house, and the only mess that is really is the time that was already there before I got arrested. But I've cleaned up the house, all the basement, the bedroom, the living room, kitchen, and I've also cleaned up the garage. And also, I'd like to say, actually, I do have a receipt from Carrie Sears. When I paid rent, I gave the money to him. That was back in February, and I have that receipt with his name on it.
Well, you don't have a lease.
I understand that.
Drug activity either.
Yes.
I mean, meth is a serious problem. That will make this property into a toxic hazard for years on into the future.
It isn't as bad as it was, but in the early days of meth houses, they were like toxic waste sites, very difficult to clean up. They did find some quantities of methamphetamine, lots of evidence of methamphetamine use, and pipes and syringes and paraphernalia all over the place. But I think, Andrew, the safest thing to do is to continue this. to next Monday.
And Your Honor, if I may say something, right now I'm in the process of trying to find someone with a truck to where I can get the trash that's that's outside underneath the carport, which I've covered up with a tarp, so it's not as such an eyesore. But I have been trying to look for someone with a truck so I could get the trash.
If I was you, Miss Carter, I would just right now worry about getting your stuff out of there, because they have the legal standing to move you out of there. You don't have a lease. You got charged with a crime while in this property. It's bound over to circuit court. You are presumed to be not guilty until found otherwise. But I'm going to continue this to 2:30, July 7th.
July 7th at 2:30.
Yes. Now let me repeat. They want you to move, and if they get what they ask for, you get 10 days from that day to vacate, or you're subject to being evicted. So they could do an immediate eviction where I could remove you right now, but I'm going to take you at your word that you have done some cleanup. But you have no lease.
Yes,
Carrie is now the owner. You're going to have to vacate regardless of a hazardous site or not. The police want the house cleaned out. Maybe it has been. There's several people that were living there are gone. But if they get what they ask for, you would have until July 17th to vacate, or the sheriff could come put your stuff out on the street.
Okay, thank you, Your Honor.
Don't pay anybody any money. Don't pay Christopher any money. Don't pay Carrie any money. Certainly don't pay Christopher any money. All right, we'll address this further next Monday at 2:30.
Thank you, Your Honor.
All right, thank you. All right, you're free to go. I'll remove you.
All right, thank you.
Andrew, I got a little update on the golf outing from Debbie Davis and from Meg. It sounds like the rain caught up with you guys before you got off the course.
Well, some golfers are made out of sugar.
Well,
some of us are just so sweet.
What Debbie said, she wasn't so much worried about the rain. It was the lightning that caused concern. So anyway, I was back here at the courthouse by the time you guys were getting drenched. So it was a nice event, and thank you for doing it.
Fred McGrew. Mr. McGrew, go ahead and come forward, sir. Sir, you are Fred Eddie McGrew III. So I got to tell you, I do not think our mic is working, Heather. I mean, I see Mr. McGrew like leaning right into it, and I can barely hear him. Mr. Taninga, do you mind testing his microphone or perhaps switching it out with yours? Because I'm having a very hard time hearing Mr. McGrew. It's not. Yeah.
This is the prosecution microphone.
Yeah.
I'll sub it out.
Could you please bring that, the one that is, I guess, at least at this moment, defective? Thank you. Mr. McGrew, I apologize. I just want to make sure I could hear you clearly. You are Fred Eddie McGrew III?
Yes.
Okay. Thank you, sir. Good morning to you. Now I can hear you.
Yeah. Before we proceed with this matter, can I state something for the record, please?
Yes, if it's factual about what happened and what led to the issuance of the infraction, I would need to swear you in first. But if it doesn't have to do with the facts surrounding the infraction, you can absolutely tell me whatever you would like.
Well, I want to preserve my rights under UCC 1-308.
Okay.
Without prejudice.
Okay.
And I want you to know that this was an unlawful stop that led to an unlawful detainment. And if you look at my ticket, he never gave me a driving infraction for anything. It was just a no insurance ticket. So that made the stop unlawful. So I'm asking you to dismiss this ticket without prejudice.
Okay, I got you. So I understand the legal defense that you're raising. So it sounds like you want to proceed with the contested hearing, challenging the infraction. Okay.
Yes.
So let me go ahead and call this case for the record. This is case 5A0273665. Mr. McGrew was issued an infraction for operating a motor vehicle without proof of liability insurance on April 19th, 2025. He has responded to the issuance of that infraction by requesting a contested hearing. Mr. McGrew, the next thing I'm going to do is I'm going to read the officer's report to get their version of what happened. You've already told me a little bit about what happened, but I'm going to swear you in and have you kind of tell me the complete story from your perspective, and then the court will make a decision, okay?
Right.
So the court's going to go ahead and take a look at the report of the issuing officer. Okay. And the court has reviewed the report of the issuing officer, signed under penalty of perjury on April 19th, 2025. And Mr. McGrew, I'm going to go ahead and swear you in. I'm going to have you raise your right hand. Do you swear and affirm that any testimony you'll offer will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. So, Mr. McGrew, you've already kind of told me some of what happened. You can put your hand down. You've already told me a little bit of kind of what your legal basis is to the challenge of the issuance of this infraction. Is there anything else you would like the court to consider in determining whether or not to find this infraction committed or not committed?
Yes, because I was test driving a car on that day. They never had any probable cause to pull me over. I didn't commit any traffic violation. He pulled me over. His reason for not giving me the traffic violation was he doing me a favor when the only thing he gave me was a no insurance because he knew that it was an unlawful stop. And they still followed me 5 minutes up the street after he pulled me over. So he never had probable cause for the stop. I didn't commit any traffic violations, speeding, no running lights, not using blinkers. He just pulled me over. So he had to give me something. And like I said, I was test driving the car. The car is not even mine. So I had to pay money already for the insurance on the car. And I don't even have the car. It was a test drive.
Okay. Okay. So this wasn't your car?
No, it wasn't my car. But however, I had to pay to get insurance because I thought I didn't know they was gonna push out the court date 2 months back. So I had to get it, but I don't have the car. The car didn't even belong to me, and I told them that.
Do you have a car right now, even if it's not this car?
Yeah, I have a car.
Do you have insurance on that vehicle?
Yes.
Do you have proof of insurance?
Yes, in the car.
Okay. Is it here?
Yes.
Okay, would you be able to bring that proof of insurance in so I could take a look at it?
Yeah, right now.
Okay.
I could go get it.
Yep, that's fine. And Mr. McGrew, while you're doing that, I'm going to call another case, but then as soon as you come back, we'll go back to your case, okay? We are back on the record at this time with City of Lakewood versus Fred Eddie McGrew III. And Mr. McGrew,
I got a question for you. This car right here, right? I got insurance for you, but why is this car is the topic of the matter when I got pulled over in a BMW 2007, and as you can see on the ticket, it was never no traffic or moving violation. So without that, is no insurance ticket to be written. So it was an unlawful stop, but I do have the insurance for my recent car, but I'm just not understanding why I got to present that when it's about the BMW.
You don't have to present it. I want to be clear.
Because I gave it, I bring it to you because it should be dismissed without prejudice, right? Because without the unlawful stop, then there's no insurance. He got to establish some kind of probable cause, whether it's a traffic violation or something, and he never done that.
Yeah. So
I got insurance for the BMW the day after, even though it wasn't my car.
Okay.
So I already paid money for an unlawful stop that led to an unlawful detainment.
Yeah.
So that's why I'm asking the courts to dismiss it without prejudice.
Yeah, I get it, Mr. McGrew. Let me ask you at this point, because I just want to keep procedurally, I've viewed the officer's report. I've heard your testimony. Is there any other testimony, any other factual statement about what happened at the time that this infraction was issued that you would like to tell the court before the court makes a decision?
No, it wasn't never no probable cause to pull over the car.
Okay.
It wasn't no traffic violation being committed. And if you look at the ticket, he only gave me a no insurance ticket. He didn't give me a speeding violation. He didn't give me running a red light, not using my signals, nothing. So without that, there's no insurance. So he didn't establish probable cause to even pull me over.
All right. Mr. McGrew, thank you. I appreciate that. So a couple of things. Court has reviewed the report of the issuing officer. It looks like the issuing officer initially conducted the traffic stop after having observed the vehicle being driven by Mr. McGrew. It appears that the officer and his partner, Officer Cooper, observed that the vehicle that was being driven by Mr. McGrew on South Tacoma Way had a dark license plate cover obscuring the license plate.
License plate cover was visible, Your Honors. It's broad daylight, so that was just his probable cause to pull over to see if he smelled something or establish an investigation on the stop.
Yeah.
But it was visible. It was broad daylight. It was like 2 o'clock.
So the court does understands what Mr. McGrew is arguing. However, the legislature has recently enacted legislation saying that license plate covers are prohibited under Washington law. And so when an officer sees a vehicle on a public roadway with a license plate cover, that is a basis for them to conduct a traffic stop. Now, Mr. McGrew has argued that he doesn't believe the officer had probable cause, but it's worth noting that under Washington law, an officer does not have to have probable cause to issue a traffic stop.
So
The officer has to have a reasonable suspicion to believe that there has either been a moving violation or some equipment violation, which is what a license plate cover would be. And if the officer has reasonable suspicion to believe that there is something about the vehicle that is contrary to Washington law, they do have a legal authority at that point in time to exercise or activate their emergency equipment and facilitate a lawful traffic stop, which allows them to contact the driver and request a driver's license, proof of insurance, and vehicle registration. Now, under Washington law, every time an individual is operating a motor vehicle on a public roadway, upon demand of an officer, they are obligated to produce proof that there is liability insurance either for that driver and or that vehicle. That is what is required under the Washington statutes. When an individual can't produce proof, either in paper form or on their phone, that the vehicle that is being driven by that driver is properly insured as required by law, it is a basis for the officer to issue an infraction. And so, Mr. McGrew, what I'm looking at here is a situation where it does appear you were properly cited for this infraction. The reason that I had asked you about the insurance and took a break in the proceedings so you had an opportunity to get that is I'm sympathetic to the argument that you're making, which is it wasn't your car, you were taking it for a test drive. And so my question about whether or not you had insurance on a vehicle that you presently own is because if you do, then even though I think technically under the law you did commit this infraction, the court is inclined to mitigate the infraction because you've already paid to have insurance on your vehicle. Operating a motor vehicle without insurance is a very expensive ticket. It's $559. And so one of the reasons that I ask people whether or not they have insurance currently is because even if they did commit the infraction, I will often mitigate the infraction amount or reduce it, usually to right around somewhere between $250 and $150. And so in this particular case, based upon the testimony that you have offered the court, that is my inclination. I do believe the officer had a legal basis to stop you. I do believe the officer properly cited you for failure to provide proof of liability insurance. But I also believe you when you tell me that you have insurance on the vehicle.
And I do have insurance for both of them.
Yep, and I believe you. So I'm going to go ahead and find that the infraction was committed because I believe it was. But I am going to mitigate the fine amount. I'm going to reduce it from $559 to $150. Okay.
Now, I ask you, how many people would come up in here with a license plate infraction? That means everybody will be in court every week because nowadays everybody got a license plate cover.
I got to tell you, Mr. McGrew, I have seen in the last several months, I have seen more than I can count. People coming in, and I feel bad for them. They're coming in because a lot of times the license plate cover that's on the vehicle, sometimes it's totally clear. The license plate cover that is on their vehicle was on the vehicle when they bought it, right? And so it was there when they purchased it from the dealer. And the legislature changed the law during the 2024 legislative session, making that illegal, and it hasn't really been highly publicized. And so a lot of people are driving around with no idea that the license plate cover.
Because a lot of police, they won't pull you over for that cover. It gotta be one of them police that you know looking for investigation to start. And everybody know Lakewood police, they love pulling you over for any little thing to create their own investigation to open up something else. And that's why I said it was an unlawful stop. So the plate was just probable cause because it wasn't no traffic violation being committed. So now,
You're saying it was pretextual.
yeah,
They use that as an excuse.
racial profiling, racial discrimination.
And Mr. McGrew, I'm not saying you're wrong. All I'm saying is that based on the information that I have in front of me, there's no evidence of that. All I can look at is there a legal basis for the officer to conduct a traffic stop? And here I concluded that there was.
All right.
Okay, so I'm going to go ahead and reduce that fine amount. Mr. McGrew, that has to be paid to the court by October 5th. You can pay it all at once or in payments, whatever's easiest for you.
All right.
And I'm going to have you come forward, sir, and we'll get you a copy of that. Thank you for being here today.